Hi there. I wanted to create a video about funding your revocable trust, essentially a workshop on how to put assets into a revocable trust. One thing that I find with many people that come in that have existing trusts is that most, if not a vast majority of trusts, are not properly funded. And I think there's a couple of reasons for that, which we'll get into throughout the course of this video. But what I'd encourage you to do is watch this video, take notes, talk to the attorney that drafted your trust, or in the alternative, give us a call. I'd be happy to help you. Or if you're in the process of starting to plan for a trust, I think this will give you some insight as to why a trust might be a good fit for you. Talking about how to fund assets, you'll start to see that a trust is a really powerful tool that we're able to capture many assets that a person might have and fund them and make things easier for the next generation. So why does funding your trust matter? First, the revocable trust really only works if it's properly funded. So we do, in most cases, have what's called a pour-over will, so that if something happens to you, we go to probate court, file the will, go through the hoops of probate court with that expense, which ultimately funds your trust. But that really misses an opportunity, one of the primary reasons that we actually create a trust. We're trying to stay out of the probate process, make things easy for your family. So unfunded assets go through probate, which is a huge pain in the neck for the people trying to manage your estate. We also have some ease of administration during incapacity. Yes, a power of attorney can be helpful, but a successor trustee managing your assets within the trust can be a really nice benefit to add to your estate plan. We also make sure that the assets that are in your trust are aligning, or where they go is aligning with your wishes. So everything that we're doing in terms of estate planning, besides planning for incapacity, is really to make sure that your wishes are fulfilled when you're no longer here. And it also avoids confusion and delay for your family. So that's kind of inherent in the trust funding question as to why we do this in the first place. And ultimately, we're trying to make this as easy as possible for your family. So here's the roadmap. We want to gather your financial information. That's step one. We want to transfer ownership of key assets. We're going to update beneficiary designations, and then we're going to review and maintain your estate at that point. So we're gathering financial information. So first, we want to think about identifying all the accounts, real estate, and financial assets. So this one's pretty easy if you have the right team in place. So in my opinion, everyone needs to have a financial advisor, should at least look into a financial advisor. And having that advisor in your corner, you've probably done all this work. And so all we need to do is have a print off of your statement of accounts, and that will tell us what needs to be funded. But sometimes real estate, for instance, it can be kind of difficult. What if you have properties in multiple states? What if you have properties or have your primary residence where there were multiple deeds with various tax parcels? We want to make sure that we're identifying each and every piece of property that we need to transfer. We then want to review how those assets are currently held or titled. So sometimes if it's a married couple, one spouse is the owner. Sometimes there's been some planning done previously where maybe there's a deed with a life estate. We want to see how those assets are currently titled to see how we're actually going to have them transferred or designate the beneficiary as the trust. And then we're also going to check existing beneficiary designations. So whenever I would say 99% of the time when I talk to people, they'll tell me, oh, yeah, my retirement accounts, life insurance, annuities, CDs, everything is properly titled. I know that my kids are my beneficiaries or my spouse is my beneficiary. So that's 99% of the time when people are alive. Much less than 99% of the time when I deal with people that have passed away is that the case. It's pretty common to see old beneficiary designations before a divorce, beneficiary designations before the birth of a child, maybe beneficiary designations before a spouse passes away before you, and then we have a dead end that we need to go through probate. Beneficiary designations can also designate that assets are to flow per stirpes, which is legal shorthand to tell us that things go to the descendants of the people that you're leaving to, and in the absence of that, to your descendants. And that can be really helpful to make sure that a non-probate asset, that's one that has a beneficiary designation, will flow outside of probate court without having to go to court. So next step, we want to transfer ownership of key assets. So first, let's talk about real estate. In most cases, real estate is going to be transferred into the name of the revocable trust. I mean, that's what we're focusing on today's video. But I would point out that there are other options. Occasionally, we'll set up a property-specific realty trust. There are some reasons to do that, especially if we're trying to fund an AB trust and want the flexibility to move between those two trusts. Sometimes we put real estate into an LLC, so this can be particularly helpful if we're worried about liability protection. And occasionally we might actually have some gifting that would occur. There's a whole host of reasons why it might not be the trust, but most of the time it is. We think about bank accounts, and there's really two ways to handle bank accounts. Well, there's three, but one of them I generally don't recommend. So let's start with the one that I think is the safest and probably the best option for a lot of people, which is actually transferring the account to the name of the trust. And so this seems kind of daunting. Occasionally a bank will require that a new bank account number be issued, which would mean that we get a new checkbook and have to update automatic payments. But by funding the bank account into the trust, it gives us more flexibility in the case of funding the credit shelter as part of the revocable trust. I'm not going to get into the exemption planning or the reason for that. Just know that it can be helpful to have access to liquidity in the trust to fund the credit shelter trust. Sort of rare, I suppose, and that's the other reason why a lot of people will do what's called a pay-on-death beneficiary, which is essentially just a form that you sign at the bank that says, if I die and a death certificate is presented, or in the case of a married couple, the survivor dies, then the assets will be transferred to the name of the trust. And that's easier in some cases because we don't need a new account number, a new checkbook, and for some clients that makes sense. And then the third option is to name somebody else as a co-owner of the property. I generally don't like this for a few reasons. The first one being that person's creditors are now your creditors. So if they're in a lawsuit, they file bankruptcy, those creditors are now going to go after what were your assets but are now joint assets with your beneficiary. The other reason that I generally don't like this option is, especially in the context of naming an adult child as an additional co-tenant, or a joint tenant, I should say, that often will cause some problems with the other siblings. So if you leave $100,000 to one of your three children because it's a joint account, you might say, oh yeah, just split it with your siblings. But how do we do that without requiring the filing of a gift tax return during the first year after death? I've seen some pretty nasty arguments with other children of that were supposed to receive this money saying, hey, I want the money right now, and the person that actually received it saying, yeah, but I'm going to have to file a federal gift tax return if I give it to you all in 1 year because this was technically my inherited asset and it's not something that would be distributed as part of the estate. And then you have the risk, of course, that the person doesn't honor the wishes and says, oh no, this was supposed to be mine entirely. So generally I don't like having bank accounts in the name of the one of the beneficiaries. Investment accounts should be transferred. These are generally pretty easy. So you can usually go online to your online account, call the customer service line and ask for a change of beneficiary form, and change of ownership form. And we're essentially naming the trust as the owner. This is also very easy if you have a financial advisor that you work with, because generally they'll take care of that transfer paperwork for you. Business interests, these can be challenging. It really depends on the nature of the business. So for a business where there aren't other partners, it's very straightforward. If there are partners, or if you're a minor partner, we'll have to look at the organizational documents to see if a transfer is permitted. In most cases, businesses will allow for the transfer of an interest to an estate planning vehicle like a trust, but sometimes you'll need sign-off from a couple entities. We might need the board of a corporation to sign off. We might need a manager to sign off. Sometimes we'll even need to send documents ahead of time to counsel for a company who will then sign off on the transfer paperwork and sometimes add in language identifying restrictions in the organizational documents. So there are some hoops to jump through, but it's really critical because what you want to avoid is a situation where going through probate is necessary to secure the business, more than just being able to get access to bank accounts. But if the business is to be sold, we need to make sure that this business continues to run, still has strong financials, and you have authority to actually transfer it to a prospective buyer within a reasonable amount of time. And then personal property, luckily, is quite easy to transfer. At the time that we sign your paperwork, we'll generally have you sign an assignment of personal property, which essentially says everything gets transferred over, which makes things nice and simple. But we want to make sure that if there are any other things that items of personal property of significant value or that we want to earmark, we want to make sure that we have our personal property memorandum completed as well. So there are definitely assets that should not be transferred to the trust. And the first one is retirement accounts. And you might be thinking, wait, hold on, retirement accounts? I thought we were funding the trust. Sort of. So retirement accounts have beneficiary designations where after you pass away, they can be left to certain individuals or a trust. The rules for how assets come out of retirement accounts can be somewhat difficult to explain and difficult to understand. They're complicated, is really what I'm saying. But generally speaking, and by generally speaking, I mean always, retirement accounts have to stay in the taxpayer's name. It's tied to your social security number. Retitling of this type of account would actually be a taxable event. And for retirement accounts like 401ks, IRAs, when you're withdrawing money, that money is treated as ordinary income. So if you have a couple $100,000 in an IRA and you retitle it, technically speaking, you now incurred $200,000 of income. Maybe you're at a 20% marginal tax bracket or 25%, whatever the case may be for the tax year that this video comes out. We're looking at roughly a $40,000 or $50,000 tax hit by doing that retitling. The proper way to do this is actually to designate beneficiaries. I recommend designating a spouse as the primary beneficiary and then either the trust as the backup beneficiary. That's especially helpful if you have minor children or children that aren't yet mature enough to manage the money in the retirement account, or at least can't be trusted not to take it all out in 1 year. And then the other alternative is to name your adult children directly. This can be helpful because then we don't need the trust to be open during the period of required minimum distributions. So for retirement accounts after the Secure Act, we have, for most situations, there are some exceptions, including spouses, people that are not more than 10 years younger than you, disabled individuals, among others. There are instances where required minimum distributions are not over the course of 10 years, but for adult children, they would be 10 years. And so if you say, I don't want this trust to have to be open for 10 years, I don't want to burden the trustee, and the children are all responsible and you're fine with them making that choice whether to distribute more than the RMDs in that particular tax year, then naming the kids directly is fine. Health savings accounts can't be transferred for a similar reason. It's tied to your social. It would be a taxable event. Vehicles we generally don't transfer for a couple of reasons. One, makes getting insurance more difficult. Two, you're probably going to have other vehicles before you pass away. And then three, at least in Massachusetts where I practice, transferring a vehicle after somebody passes away is generally quite easy with either a spouse transfer form, which is essentially an affidavit that gets filed with the RMV and a new title is issued, or we can do what's called a voluntary administration, which is not a true probate proceeding in the probate court, but it is quite straightforward, and it's generally pretty inexpensive, costs around $100 in terms of filing fees. And then annuities, of course, we want to make sure that those are not transferred in terms of ownership because there can be penalties. This is, again, another area where you'd want to talk to your advisor to make sure that if you do have an annuity that you're transferring, you're not incurring a penalty or, for instance, it being counted as an early withdrawal. So we also want to update beneficiary designations. And so we talked a little bit about retirement accounts. We want to designate surviving spouse, and then the trust or adult children are the other beneficiaries if it's not adult children. Life insurance, we generally want to name the trust for the same reason that it's good to have the bank accounts in the trust as well. It provides a liquidity that if we need to fund the exemption trust, the credit shelter trust, we have that money available. Annuities, generally we want to name the trust as the beneficiary on the annuity for the death benefit, and then we talked about the possibility with a bank account to designate what's called a POD beneficiary or a pay on death beneficiary. So these generally will happen once the trust is created, and again, having a financial professional help you with these transfers can be really helpful and also minimize the risk that there's an error at some point in the future. So one question that I get a lot is, how often should I be reviewing my trust? And it's a really good question. And the answer is, you're going to want to review things more in different ways on different timescales. So I like to recommend an annual mini review. The easiest way to do this in terms of remembering is to say, when you file your taxes, just take out your trust, read through a couple of sections. Who are the beneficiaries? Who are the trustees? Are you still close with these people? Are they still the right people to make sure that your wishes are fulfilled and ultimately receive your assets? There are other reasons that you'd want to call us sooner than an annual review. So if somebody in the documents was to pass away, if we have a major medical diagnosis, if there's a large inheritance, and again, this is kind of a squishy term, but something that's going to potentially make your estate taxable when it otherwise wouldn't be. Those are some of the reasons why you'd want to call us before that annual review. And in most cases, the changes that we would do are done with an amendment that is relatively inexpensive and easy to do or to put into effect. As part of that annual review, or in conjunction with, usually you're going to meet with your financial advisor. And for a lot of financial advisors, they make it a point to meet more often than annually. But generally, as part of their process, they're going to say, okay, what are some of the estate planning goals that our client or my client has? And what do we need to do to make sure that those are updated? I also recommend, as part of that annual mini review, to verify your account statements. And you don't have to go crazy here by saving all your account statements and putting them in a binder or a folder or something like that. But generally, once a year, just make sure that your list of accounts that you have matches up with the name coming on the statement, is in the name of the trust, or confirming that the beneficiary designations are correct. Generally, there aren't any issues, but you want to make sure that everything is captured. Sometimes a new account's opened. When you go through that list and you say, hey, why isn't this account in the name of the trust? That can be really helpful and avoid an issue in the future. And then every 3 to 5 years, you probably want to review your documents with an attorney. When you're reviewing with an attorney, we can talk about changes in the law. So perhaps the exemption amount for estate taxes for Massachusetts has gone up or down. Perhaps the federal estate tax has gone up or down. Maybe there's a change in the way that the IRS is treating, for instance, a step up in basis. Maybe there's some other reason why we want to make a change that isn't just, has somebody been born, somebody dies, somebody no longer should be a beneficiary, and so on. So meeting with an attorney every 3 to 5 years is an important step that I think a lot of people don't actually do. I wanted to touch on a couple common trust funding mistakes. So one is that people forget to transfer assets to the trust. I mean, that's pretty obvious based on this video, but it happens all the time. And unfortunately, when we're going through probate, we can't just tell the judge, hey, they forgot. We have to actually go through the whole process. Number two, they retitle retirement accounts in the name of the trust. This is pretty rare, but it's really, really bad if it happens, which is why I've hit it twice now in this video. Assuming that their revocable trust gives them asset protection. This happens all the time. People will come in because they've done documents before. Maybe they got their documents done 10 years ago, and they come in and say, oh, no, I'm protected because I have a revocable trust. And that's simply not true in Massachusetts. You are protected in certain ways, so your beneficiaries might have creditor protection in the future. You might have protection from going through probate court, but you do not have creditor protection that you would get either from an LLC for third-party liability or with an irrevocable trust for Medicaid protection. Another common funding mistake that I see is that there's no updates to the actual document. So sometimes we'll acquire assets, and for instance, let's say a vacation home is added, and you want to leave that to one or two of your beneficiaries rather than all of them, and we don't see that update being reflected in the trust if that vacation home is even titled in the name of the trust. And so those are things that you want to be really aware of and make sure that they happen when you actually create the trust or acquire a new asset. And that brings us to number 5, which are inherited or new assets. And so those could be something like an inherited IRA. It could be a brokerage account, so essentially receiving stocks. We could have new assets in the form of a very expensive car, a boat, something where we might consider actually transferring title to the name of the trust. And so these are just some of the common mistakes that we tend to see. So I want to thank you for watching this video. Hopefully this provided a little bit of guidance and a little bit of help in terms of what needs to be done to actually make sure that your trust is funded correctly. If you do have specific questions, you want us to take a look at your trust to make sure everything is done correctly, or after watching this, you think, oh, I actually should probably talk to them about creating my first trust. I'd be happy to help you. All you have to do is call our office or visit our website. You can actually schedule completely online by visiting our website. And if you found some value in this video, I'd really like you to subscribe or give us a like. Those can really both help us reach more people, but also it tells me that these are the types of videos that people want to see. So until next time, I look forward to talking to you soon.